Any mention? May I please, Your Lordship? I beg to mention item number 14.
Yes.
Lordship, I pray for 2 weeks' time because a similar matter is still pending in the division bench.
No objections. You have it after 3 weeks, I don't think, because this matter, so long, you see, like, somebody comes here as a new CJ, I don't think there is any likelihood of matter being taken up by any bench. Yes, yes. Let us have it after 3 weeks, I think. Yes. Yes. How did you just say the request made by the petitioner is not after 3 weeks? Yes. I'll oblige.
May it please Your Lordship. Lordship, I beg to make a mention of item number 2.
Yes.
Lordship, I'm praying if this matter may be listed after a week's time.
Why?
Senior conducting counsel is out of station, Lordship.
It's a matter like you're supposed to take some instruction. You don't need a senior for taking instruction.
Lordship, I've been unable to receive those instructions from the
It's
clients.
pending for quite a long time.
Lordship.
There is a limit. You see, like you've been asking time for taking instruction for quite some time. Until now, we have not. Yes.
No objection, my lord.
Subject petitioner prays for adjournment. The petitioner prays for adjournment for 2 weeks. The respondents have no objection. Prayer alert, list after 2 weeks.
Lordship, a similar prayer for item number 3.
Who is there in item 3?
And
Here. This is also 2 weeks.
Lordship, 2 weeks.
Same order here.
Highly obliged, Lordship.
May it please Your Lordship, I beg to mention item number 5.
Yes.
Your Lordship, kindly have this matter after 2 weeks, Your Lordship.
My lord, no objection on behalf of the state.
5. The request made on behalf of the petitioner, list after 2 weeks.
Similar prayer for item number 12, Your Lordship.
12, who is the other side?
Similar prayer for item number 12.
Who is the other side?
yes, my lord.
Yes. 12 also, same order. Yes.
Obliged, Your Lordship.
May it please Lordship, I beg to mention item number 6. Your Lordship, I pray for 2 weeks' time, Your Lordship. Settlement process is still going on, Your Lordship, in this matter.
This is also another matter pending for compromise.
Yes, Your Lordship.
Nothing has been done till now.
No, Your Lordship.
You should have some instruction in this matter.
We'll take instructions, Your Lordship.
It's pending for quite some time.
Yes, Your Lordship.
When?
After 2 weeks, Lordship.
This also 2 weeks of the request. Yes.
Obliged, Lordship.
Obliged, Lordship. So I beg to make a mention for item 8 and 9, Lordship, on behalf of Ms. R. Dattai, Lordship. Late.
Yes.
I'm praying for 2 weeks' time, Lordship.
Here for the respondents, both the matter. 8 and also 2 weeks at the request made on behalf of the learned legal counsel. Applying for the petitioner. Yes.
Deeply obliged.
Deeply obliged, Lordship.
Daily causeless, item number 1.
Hearing item number 4.
Yes. Nobody for the petitioner.
No, Lordship.
None appears for the petitioner. MS Pradhan is present on behalf of the respondent.
Respondents.
This is matter of trial.
Highly obliged, Lordship.
Item number 7.
Lordship, the learned DSGI is on his legs. Lordship, may kindly take up this matter at the end of the board.
You are ready?
I'm ready, Your Lordship. Preliminary objection was made out by the learned senior counsel regarding the maintainability of the writ petition, Your Lordship. Whereby what exactly has happened was that after the petitioner has challenged the entire proceeding of the GCM before the MHA also, and that appeal was pending before MHA. And in the meantime, Your Lordship, that was the maintainability challenge which was raised.
The appeal was pending.
Yes,
before,
but
yes.
in the meantime, Your Lordship, I have an instruction that the appeal also disposed of, Your Lordship.
Yes, and this disposal in whose favor?
In the favor of the respondent, Your Lordship.
So then means you have to challenge that order of the
Yes,
of
Your
the-
Lordship. Yes,
Then you have to file a fresh.
Yes, Your Lordship.
So you withdraw and file a fresh.
I'll seek instruction, Your Lordship, since.
Learned counsel for the petitioner prays for grant of some time for obtaining fresh instruction in the matter. Accordingly, this is matter after 2 weeks. You minimally obtain instruction and just
Yes, Your Lordship.
because if there is a decision by the appellate authority, then you have to challenge it.
Yes, Your Lordship.
So you have to do it by filing another. So this will become infructuous.
Yes, Your Lordship. I'll do that.
Highly
Deeply
obliged,
obliged.
Lordship.
Item number 10.
Item number 13.
This proceedings for the this is against the Wildlife Act. The vehicle was seized.
Who is
Wildlife?
representing the other side?
That is slightly unfortunate. We've been trying for last 2 months. Notice was served. Nobody is appearing.
Okay, notice is served. Now none has entered
None has
appearance.
appeared. We don't want this case to be heard ex parte because important issue is laws involved. When we had moved the motion in lordship, we had received instruction that the vehicle was released on Jimma, but it was still in the custody of the court. But subsequently,
What is the matter, Rava? What is the?
Weta was lordship a very important issue of law is involved under section 39 of the Wildlife Act. Once the vehicle is seized, it becomes the government's property. And lordship was of the view that this cannot be a correct position of law.
What is the law? The law says. See, apparently it seems to be that is what was there in the mind of the court. Is there any decision of Supreme Court with regard to this?
Some decision is there, lordship, but it's not parametery with the act. That is where the problem. So I don't want to rely unnecessarily. We read the whole judgment and then we file 2 different acts involved. I relied on the mother.
No, just it is basically exactly on the issue.
Madhya Pradesh judgment I realized, your lordship, Sayyid Ali, which says no, it cannot. It has to be confiscated. Then lordship was of the opinion. Then lordship threw a very interesting legal question whether CRPC will be applicable, even if the parent act is silent on the interim Zimma. Whether CRPC for section 457 will be applicable. So it's a very interesting issue of law. If it's that applicable lordship, then I don't have a case. But then the issue of interpretation of law will be required. If the Wildlife Act is silent, can the court resort to CRPC and accept the contention that Zimma is applicable if the Act itself does not speak of Zimma? And lordship, we know this court very.
This matter tomorrow because in absence of the other side.
Absolutely,
Since
lordship.
there is a question of law involved.
I also don't want. That's why lordship we've been asking for time. We're trying to.
Must do some homework, you see, because this is a.
And lordship, we are open to this suggestion that irrespective of whichever way the outcome comes from this honorable court, the issue of law will be settled because we have a number of cases of wildlife in Meghalaya. So and lordship rightly said that this could be bordering around being a very draconian law without trial being held. But rightly or wrongly, we were not into that part. What our constraint is this within the 4 corners of law. If the Act does not provide for interim, can the court on its own invoke it? And knowing this court very well, lordship, this court, honorable court, always imposes self-restraint.
What is the order which
Order, lordship, is a concurrent finding. Very surprisingly, lordship, the appellate court held that I do not agree with the submission. That choice of word in the order itself is very, very. If I come to page 26,
the appeal was filed because.
Lordship, I'll just give the background. The Zimma application was moved before the magistrate. There's again a factual issue involved. The rightful owner did not file. Vehicle belonged to somebody else real estate owner. That is a disputed question of fact, of course. And then the trial court granted Zimma, in spite of the fact that the real estate owner was not there.
But then, whether registered owner has made any subsequent claim?
No.
Then it's okay.
Yes, lordship. I'm not going to that, but that is hardly immaterial. And then the issue of section 39, if the property belongs to state, that was not considered, neither discussed. And when the matter came to appellate court, then the state filed an appeal against the order because it wanted to test the veracity of section 39 of the.
This order was appealable.
It was appealable. Technically speaking, lordship, that is also a grey area. Technically, it's not an appealable order. Lordship had already explained.
This is something.
An appeal was filed under 382. It was not appealable. But then court did not go into that issue. So, lordship, there could be 2 situations if court feels like matter can be remanded back and says file a revision, file an appeal. So I have to overcome that part even, whether it was appealable or not. And all said and done, the session judge could not have conferred jurisdiction on itself in the absence of valid proposition of law being or provision of law being
The
enforced.
respondent was represented before the appellate.
Lordship, yes.
Was he represented by local counsel? No.
Some local counsel were there, Gautil laws were there. Only a very interesting issue is lordship. If the lordship comes to the conclusion procedural law is applicable, then it will have a binding effect and a lot of wildlife cases. The other day, the DFO had come, Your Lordship, and I asked him, we had a lengthy discussion. He says, like, we need clarity on this particular provision of law because we have got a lot of exotic birds and animals, and people from outside the state, they come to the wildlife sanctuary. So slightly there is a grey area in so far the procedure part is concerned.
Then we have to go through those orders and all.
Lordship, yes.
It's okay. You can, if you want, you can carry on. There's no
No, Lordship, we can suggest one thing, Lordship. Maybe have it next week in a day when Lordship is relatively free. Lordship can go through it. I'll
No,
also
you say, like, the things will remain like that since there will be other side counsel. See, like this, it is not possible for this court.
we can't insist. We can't insist anybody to appear
Go
also.
through and all those things. But then since
But Your Lordship, if I make a candid
we have
submission,
raised an important question of law, so we just cannot.
and Your Lordship, as I submitted, irrespective of whether my 482 application was dismissed or the appellate order is upheld, we need a bit of clarity on the issue of law. Because Your Lordship, the situation is very, very complicated now. What happens in most of the wildlife sanctuary in Meghalaya? People from outside, they come, and the forest official, they, by chance, search or by prior information, they seize the vehicle, and there are wildlife there.
We have seen the finding of the appellate court.
Yes, Lordship, yes.
It says that the vehicle was not involved in transportation of those.
Yeah, that's why I said, Lordship, there are, other than the legal issue, there are other factual aspects, but maybe we will not touch that factual
The
aspect
vehicle
because.
was not transporting those exotic birds. That is what it says. Now, if this is
No,
a finding of fact, which way this court can say that it is not correct?
amended as per 2022.
Lordship, that factual part, Your Lordship, we can satisfy. In fact, in the last occasion we satisfy, the appellate court, Your Lordship, overlooked the Amendment Act and the details of these birds. It relied on some other some other notification which is not relevant. That is, Lordship, there are two issues as I submitted, Lordship. First is the issue whether the CRPC will be applicable for Zimma. Second is whether these birds are exotic or part of the Wildlife Act. And in the opinion of my respectful submission, Lordship, in the opinion of the appellate court was that these are not part of the Wildlife Act or not. That patently is perverse on the face of the fact, because we can satisfy a court, Lordship. That is not the case. So two situations is there. Whether Zimma can be applicable when there is a complete bar by the statute and the property belongs to government. Second, whether it comes within the Wildlife Act.
It's a 482 application.
Lordship, yes.
Why 482?
Lordship, because against appellate, because this
Why not 397?
that should have been before the appellate court.
That is what the apex court says.
Absolutely.
If there is a remedy prescribed.
No, Lordship, that 397 should have gone first before the appellate court. Unfortunately, that issue was not argued.
No, but then right now your challenge is against the order passed by the appellate authority. So you should have invoked why inherent jurisdiction. It is not that the other side is preferred anything.
No, it is me. Lord, it is me.
Now you cannot come and say that this appeal was not maintainable.
No, I cannot. Absolutely, Lordship. But Lordship, kindly consider this is a procedural hazards in any case. Yes.
Illegality, why not? Why don't we basically adapt the courage?
Lordship, but whether it's 397, 482, ultimately, the procedural part is blurring. There is no final decision of Supreme Court. It says, okay, in any case, suppose.
No final, but then there are decisions which.
Lordship is correct. I'm aware of it, Lordship. The same thing, we discussed this in the day when the motion was moved. So I said, Lordship, in any case, if the Lordship feels 397, we could have done it. That's not the issue 482 or 397. The substantial issue is the Lordship of, for the ends of justice, a serious issue of law is involved. That part, we can rectify if the court finds, yes, interim Zimma is maintainable under the CRPC. Or factually, those facts have not gone into by the appellate court, neither by the trial court. And then The opinion of the appellate court, Lordship says, I don't agree with the position of law. That is very unfortunate. It chose, the appellate court chose even to overlook the law. It did not say Zimma is applicable. It says, I don't agree with 339. So, Lordship, this is a confusion that has happened in the trial court and appellate court. So, we need some clarity on the position of law and the procedure to be adopted by the DFOs in future, for future guidance. As a summary, Lordship, irrespective of whatever happens to this 482 application. Now, there will be consequences, Lordship, when genuine cases will just collapse or will fail to face the trial because of uncertainty in the procedure.
One left, Wildlife Protection.
Wildlife Act. No, to the court.
What is the section
Section,
which says that seizure made would be the property of the government?
Lordship, that is section 29.
No, section 39.
39, sorry. Apology, Lordship. I'm too busy with 39. And Lordship, we are aware that this court always imposes self-restraint when it comes to going outside the meaning of the act. So I also feel like we don't know what is to be done in a situation like this.
What is the stage of the trial with the which has been initiated on the basis of the
That, Lordship, that is proceeding.
now when this vehicle can be said was used for transportation of
Lordship is absolutely correct.
this is only at the conclusion of the trial.
The Lordship has absolutely made this thing very clear in the day one, and Lordship said this needs to be answered. And our situation, Lordship, is can you see after D 139(1) D.
Yes.
After D, Lordship.
Yes.
D says every while. So if you start from every vehicle used, vessel, weapon, trap, or tool that has been used for committing an offence and has been seized by the provision of this act, shall be the property of the state government, and whereas animal is hunted in sanctuary. We are not concerned with this, Lordship. First part shall be the property of state government. Had it been me, Lordship, we would have had a leeway for the court to bring in 457 or 451 of the CRPC. But the word shall. Now, at what stage that is required to be interpreted?
You are confined on this, but then at what stage you say that a vehicle is used?
It is
finality can only be arrived at.
Common sense, Lordship, that's a common sense approach. The finality after finality happens. Otherwise,
because
no.
vehicle is seized, you cannot say that.
And Lordship, it has fallen for your code from this Lordship also that this could appears to be apparently a draconian provision if you don't interpret it. And so far, Lordship, the commission of the offence is concerned, it was transit. The vehicle was in motion, the vehicle was seized, but that is not the issue. I understand what is coming from your Lordship. The issue is not that. The issue is at what state can it become a state property?
Is there any provision in the Act which allows the court to presume, like the POXO Act?
No, it doesn't.
Then what is the question of holding at this stage that vehicle was used?
Lordship,
because the seizure was made, we cannot say that it was used.
Lordship, I am in the same page as your Lordship so far this question is concerned. but the question comes, Lordship, which way we interpret this? We'll have to explore the possibilities. Should we read down, or should we overlook it, or should we restrain the meaning of shall to may, or should we say that no, in spite of the fact of shall?
See, right, at this stage, you don't think that the shall or may is.
Then Lordship, we know this court. This court will impose a self-restraint and says nothing doing. Let the Parliament amend the law. So Lordship will kindly appreciate that is where the confusion is so far the Wildlife Act in Meghalaya is concerned. I'm apology for repeating again. As I submitted, Lordship, irrespective of whatever happens to this case, that a merit will take its own course. But then which way should we go? I had a very lengthy discussion with the forest officials, Lordship. So they also said we want this case to be decided by the High Court only for that reason. Kindly get the clarity on the procedure.
What is your ground of appeal here?
Lordship, our main ground.
You are ready with the thing. You are ready with the thing.
Lordship will. I was hoping the other side should have been
Yes.
there, but in the absence of that, Lordship, I don't know. Kindly then, Lordship, we can go through it. I'll just do a bit of research more. So let's see if some judgment comes.
The presence of other side was.
It is very important.
Otherwise,
Lordship.
would have been a
Ex
very-
parte will still
very
not.
much help-
Lordship, ex parte will not be binding in the court because the procedure will still remain. And I don't know. We want some authority on this part. So Lordship, kindly fix it. Otherwise, next week, let's see. Let me see if we can.
If you give us your points.
Lordship, there are two major points, Lordship. First is this: the trial court and appellate court has totally disregarded, not even discussed the 39 part. And number one. Number two, it has not even answered the very important question of 451, whether 451 will be maintainable whenever Wildlife Act is set into motion. Had that finding been there, Lordship, it would have been easy for us to either argue for or against. In the absence of that vital discussion and adjudication, the trial court and appellate court order appears to be perverse.
See, let us just go by your ROCAS at this stage.
Lordship.
Now, it is not that the government is a registered owner of the vehicle.
Lordship.
Now, you cannot raise a grievance if the vehicle is released to somebody
Absolutely correct.
other than the registered owner.
Absolutely
because
correct.
registered owner is not here before.
Absolutely correct. Lordship is correct.
Now, your main thing basically is on the basis of 39
39.
D.
Lordship.
Where
Shall
you
be the
say that any vehicle involved in the trade of these exotic birds and all would be the government, if it is. Now, that is where we say the query of the court is the 39D. At what stage it will become clear? Whether it is at the just because case has been registered at the stage when the investigation is going on, or at the end of the finding record will be filed.
Lordship, before the court has put their query, in fact, like before even the court put, I had put their query to myself.
Now, what is the law with regard to that? At what stage?
The question.
The D will become operative at what stage?
Lordship, D will become, if you come before that, if you come to section 15, Your Lordship, 50, the same act, Your Lordship. 50. Which one? 50, the relevant part will be C, Your Lordship.
That concerns the power of entry, search and arrest.
Yes.
C, yes. That is not relevant, Mr.
Absolutely. Lordship, the purpose of my endeavor in reading this was this, that Caesar part, the first part was overcome.
It's okay. We are right now we are concerned with the question at what stage you can claim it to be a property of the government.
No, Lordship, then we have to answer two very larger issues. If the act is silent, can we legislate by judicial interpretation?
There is no question of legislating. We will have to interpret the
No, Lordship, Lordship, I agree with the reply. In fact, that would have been my reply too. But the second issue would be if it is silent and we are not going to interpretation, then whether 451 will be applicable. Now, that needs a larger issue. If whether 451 of the CRPC will be applicable for Zimma.
Is there any other provision in the act for taking Zimma?
No.
Then?
In either way, Your Lordship, we will have to venture into that territory where we have to interpret.
Do you want to say the
457
CRPC will not be applicable?
No, I'm not saying, Your Lordship. This act is self-contained, inclusive.
Then why you are disputing the question of application of section 451?
Lordship, I'm not disputing that. What I'm saying is this: if it shall belong to the property of state, then I'll come back to the question that the court has posed. At what
Property of
stage?
the state only on the
What-
basis of 39D, nothing else.
Nothing else. At
Now
what
the-
stage?
let us simplify. You see, like if we make it complicated, then we will not be able to answer.
So
it.
let us answer that, Your Lordship, at what stage? How do we answer that question? The
Yes.
question comes, how do we answer
39D,
that?
you just address the court at what stage it can be.
My reply, Your Lordship, would be if the stage has not been spelled out in the act by the legislation. We are at a dead end, we just don't know where to go. Because all our actions will be totally.
No, in such a case, if you take an action,
Ah.
you cannot say that we have taken action without deciding what would be correct action. Once you
Exactly.
take action, then you have to support it.
Support it,
That
absolutely.
If you approach the court
Yes,
saying that this is now our property,
right.
then you have to support that.
Nee,
For supporting that, you have to give us law. That is
absolutely.
what this court is asking.
Absolutely.
You just cannot just put the question to the court after filing the petition. No, please you give a right.
Nee,
No.
My,
You say you give. What is your assertion?
my assertion is this: the word "shall" belong to the property has to be literally
That is
interpreted.
okay, but then what
Nothing,
stage?
nothing.
We
Lordship, I
have
don't
no
have.
dispute with the shall.
I don't have
But
any.
then-
Lordship, I don't. I'm sorry, Lordship. I can't forget. I can't forward any other argument. If the word "shall" belong to the government property was not mentioned, then maybe yes.
Mr. Khan, the dispute is not there. At what stage you hold that a vehicle was used
Lord,
for transporting?
Lordship, can I give a categorical reply?
Now, at what stage?
Lordship.
Does it mean that just because you seize a vehicle, that becomes a conclusive proof of use of the vehicle?
No.
Can we say at this
No,
stage?
no.
So now we are at the stage where the seizure is made and vehicle was released.
Absolutely.
Okay,
Absolutely.
but then we have not come to any finality
Absolutely.
with regard to the use.
Absolutely
This
correct.
only a trying court can
Absolutely.
say.
Exa-
that
After
vehicle
trial.
was used
After
or it was
trial.
not.
After trial.
But then before that, it is only a suspicion and the allegation of the state.
Absolutely correct.
Now, can this 39D be operative at this stage?
That's the
That
question.
is what you have to answer.
Lordship, I am in the
Please
same.
give answer to this, and then otherwise
My
there is no
my
question.
Lordship, my answer is constrained by the simple fact. At the best, it can be my opinion. At the best, it can be academic. It cannot have any persuasive legal value, Lordship. Why? Because the legislation is silent on that. I don't have any luxury to forward any legal argument because the constraint that the law has laid down is
Then we
on
will
that.
say that you have filed this application, but then you have nothing to support it. So
No,
we will
my
not
my
interfere.
my
until unless you make out a ground for interference,
my
just only on the basis that there can be a different interpretation, we are not going to interfere.
if I go by the literal interpretation, the law clearly says shall be the government property.
That comes at a later stage. This court has no problem with that word shall.
Yes.
Doesn't see any difficulty with that word at this stage. The question before this court is right at this moment is that at what stage we can hold that a vehicle was used for transporting humans.
The act is silent, Your Lordship. That is where the problem is.
That is what. Do not go to that shall.
Ne-
This
ne-
court has no
then-
problem with that
Then,
shall.
then, then the act is silent on that aspect, the query.
You are challenging it. It is your duty to say
Ne-
which way we should interpret it.
My limited argument would be, since the act is silent on that part of at what stage. That's not the issue. So since the act is silent on that part, whether at what stage, Your Lordship, how can I forward a legal argument on that? I can just say
Then we will say that there is no merit in your application.
no, Your Lordship, it's not merit on law.
See, are you trying?
But Lordship, can you appreciate? If Lordship says no merit in the application, will the Lordship then hold
See,
that
we-
that at
we
what
do
the
not-
stage
do
has been
take
not
up a
answered?
Litigation just for mere academic interest. We are not sitting here to settle down a question of law.
No, absolutely,
until and
absolutely,
unless it is
absolutely,
required
absolutely correct.
in deciding certain matter. Now, your challenge is to the order passed by the trial court and the appellate court. Now, you just say which way you dislodge those orders. Finish.
Lordship, on factual,
For deciding that or deciding your contention, if we are required to embark into that question, then we will embark. Otherwise, there is no.
otherwise no.
That is
Then Your Lordship, on factual part, both the lower court and the appellate court has not decided the issue of which law under which law whether 457 would be applicable. So factually, it's a perverse finding by both the court.
doesn't matter. Just say, just see. Take together your interest. your claim is on the basis of the 39D.
Right.
Now, first you establish before this court that at this stage you have a right to claim the property. You place a law before this court that mere fact of seizure is enough to hold that the vehicle was used for.
That is a
transportation.
that is a relevant question.
If you can
Yes.
solve this law, then you have a case.
Absolutely, Lordship is correct. Unfortunately, the entire act is no. The Lordship, then I'll just try to find out if there's any law on that.
And having interaction with you is for the purpose.
No,
To a
absolutely.
point,
No, absolutely.
and center it there, and around that we just.
If there is a,
Otherwise, it's very difficult. You see, we can understand your anxiety. You want to see that this question is settled.
as I said,
But then
Lordship,
we cannot forget the matter which you are having before us.
no, absolutely.
You please do some research on those, and then.
No,
find out
we'll try to
some
find out. We'll try to find out on that.
Since it is interesting point, since you have raised it, just see at what stage the 39.
At what stage? That is important. At what
And
stage?
once you can say this, then definitely
Definitely we'll try to find out.
there is no dispute with the proviso to the 39. Where you say you are
The
pointing out
only
the
issue is whether
prejudice.
at what stage.
What stage?
And what stage then whether CRPC Zimma application will be applicable.
When shall we have it?
Lordship, next week.
You'll be ready with next this thing.
451 and 457
Lordship, another aspect of the matter is whether 451 or 457 also will be applicable. Because the Act itself does not contain final releases. The first question, Lordship, no doubt about it, we'll try to answer, but again, whether I don't know if the court wants to enter into that area. Or,
No, until unless you can show that you are directly aggrieved by the order. Why is the question of going to other issues? Which you are aggrieved, that matters.
okay.
If you show this court, if you are able to show this court at this stage that you are supposed to, you see, like own that property, or you are supposed to have a legal claim on this property, then it's okay. But then until unless we are satisfied with that, we cannot go into other things. See, this very appellate jurisdiction which you have invoked,
That is
wrong.
irregular. At the best, we can say
Problem.
irregularity was there. Absolutely, Lordship, not the correct provision. That always is there. Then we all have those problems, Lordship, dealing with them. Okay, Lordship.
Then again, that 482 application, that is also one other area. Had there been any appearance from the other side, had there been objection, then also.
But Lordship, I just submitted 397, 482. It sometimes overlaps, sometimes borders around, sometimes it goes to the substance and says miscarriage of justice.
Mr. Ketan, thinking of the state, non-appears for the respondent. There is only one respondent.
Only one is.
Non-appears for the respondent. This is matter when? After?
After a week, we'll try to, Lordship, at least 2 weeks, Lordship, we'll try to find out something.
After. Anyway, you take time, but then come with definites at all, not here, there, and all. Do not hit around the bush. Hit the target.
Lordship, my problem is different. I'm trading alone in a desert. There's no bush around.
Yes, please proceed, please.
Oh.
Item number 15.
May I please, Your Lordship?
Yes.
My Lord, I must pray for some time to file an additional affidavit, my Lord. Here, basically, this is section 482 applications where we have before my Lord for quashing of some allegations against me and an FIR against me, my Lord. My basic contention was that this FIR it's maliciously done with to wreak vengeance against me, nothing else.
You have a heavy burden then.
Yes, my Lord. So now what happened is that, my Lord, and we every now and then we are mentioning about an inquiry report, my Lord. And on the basis of this inquiry report, 7 FIRs have already been filed. And even in this, the FIR that has been filed, which I am before my Lord for quashing, is also mentions of the inquiry report of submitted by the department, my Lord. So it becomes very important for me, my Lord, to show the inquiry report first, and also the different FIRs that has been filed emanating from the same inquiry report, and to show my lord the present FIR, and that will assist.
What bearing that inquiry report will have in the outcome of this matter?
My lord, one thing is that there are a complaint, that this is the second complaint against the same allegations. That is one, my lord. That will be subjecting me to a double jeopardy, my lord. Because on
jeopardy at
yes.
this case, how we will decide?
My lord,
Sir, is it your contention that there could not have been 7 FIR? There hardly at the best there could have been 1 FIR. Are you
that issue is different, my lord. That issue has gone,
so
because I've withdrawn that.
Raising that.
Yes, I've not raising that one. That issue, since I've taken, there was my lord will recall that there was another 482 applications which I've withdrawn because the charges have been filed, my lord.
Yes.
Now finally this is the 5th FIR, my lord, that is coming before my lord. This is the 5th charge, and this is at a nascent stage of investigations, my lord. And this also emanates from the same inquiry reports. Allegations are there from the same inquiry reports with regard to some registrations of vehicles.
So are you raising a plea on the basis of the law laid down in T.T. Anthony's case? No.
Then the Anthony's case also is there. Lalita Kumari's case will be there. Then the other the landmark.
I mean, like, they're the same proposition.
Yes, the same propositions will be there. But my lord, I was last night I was preparing this the matter for argument. Then I felt that, my lord, this inquiry report that will assist all of us.
Definitely. If you have any argument based on the basis of that T.T. Anthony or Lalita Kumari's case and all,
my lord,
then definitely this inquiry will have some relevance.
My lord.
Now, that was the actual purpose of asking you.
My lord, yes. So, my lord, kindly allow me just a week's time. I will bring it on record.
No problem. You see, time that is no dearth of time. Plenty of time. These are new matters. This court has no problem.
My lord, yes, it's a 24 matter, my lord.
Yes, Mr. Shulai, what do you say?
Yes. Let me file that.
Now, if that be the thing, if this FIR originates from one inquiry report, can there be multiple proceedings in person?
Lordship, there is a provision under the CRPC, Your Lordship, for clubbing that issue has to be raised before the.
Now, clubbing together is one thing.
Yes.
And you see, like, filing separate cases.
Lordship, because the law permits, if the distinct offences are revealed, then Lordship, that is permissible, Your Lordship. But so far, clubbing, Your Lordship, that issue, that question has to be raised before the trial court, Your Lordship. I forgot that section. There is a section under the CRPC.
Yes. That is the reason why I have withdrawn the other 7 FIRs from my lord.
In fact, earlier also I read criminal petition had been filed for clubbing. That the moment that provision with CRPC is pointed out, that they sought to withdraw it. I think 2 to 3, Your Lord.
Okay. Hard Lana Council for the parties. Mr. Young, Lana Council for the petitioner submits that the inquiry report, based on which the FIR in the present case was filed, is required to be brought into the record of this court for proper appreciation of the matter. The Learned Council prays for grant of some time for allowing to file an additional affidavit for the purpose of for the opposite purpose.
And also, my lord, the 7 FIRs. But that 7 FIRs that will be bring on record, I'm not going to argue for clubbing or for quashing, but just for the purpose of showing the contents.
That's why you can say it. You can do one thing.
Yes.
What we said? What was it? The petitioner shall also liberty to bring into the record other connected papers.
My lord.
Which may be relevant.
My lord.
For the purpose of adjudication of this
My
matter. Mr. Andy, shall I? No, then once we have given, it's all right. Before giving the last line, just say Mr. So and so AG, learned AG has no objection to the prayer made. Then thereafter you say the petitioner shall have the liberty to so and so. Okay. Give full stop. Then when shall I release this matter after?
Within 1 week time, I'll file it in 2 weeks from now.
This is
We
matter
can
after
file
2
it.
weeks.
We can argue.
Obliged.
Obliged.
No, then